How have the lawyers and funders reacted to the decision?
Right now, case organizers are scrambling. Thankfully, courts left common fund orders in place in pending cases, but they're not ordering any new ones. In response, many funders are backfilling registrations in pending cases that lack common fund orders. They've already committed to these open matters and are financially at risk, so they're looking for every reason to ask class members to sign, to contractually lock in their commissions with as many class members as possible. Going forward, some funders will still file open, particularly if they have anchor clients. If the funder is economically most of the way towards its minimum, it can capture the rest later by reopening the closed class to accept new registrants. Courts will often permit this, and if the parties engage in settlement attempts, the defendants may also want more investors included to buy a broader piece. Other funders are vowing only to file closed or opt-in classes in the future following book builds, returning us to the pre-2016 days. The response from the lawyers will be the most interesting and potentially determinative for investors. We're seeing at least one case now being proposed by counsel on a conditional fee basis without a funder. So right now we're in a period of flux with different workarounds being tried. The key will be landing on one that permits continued filings on an open basis. If that happens, then from the investor's perspective, things will continue to look much as they look now.
So what workarounds are being tried, Mike?
Well, when we discuss workarounds, we need to distinguish between short and long term. Short term, there are three things being considered: equalization orders, closed classes, and open classes with lawyers charging conditional fees. So let's look at each of those. Equalization orders. These are implemented in open class actions at the settlement stage. They are designed to put class members who did not register earlier in the same economic position as those that did. Basically, the court takes the total financial commitment for the group that registered earlier and spreads that amount across all class members. It's meant to disincent the free riders. The problem is the funders don't get paid any more with an equalization order. The same amount is just getting spread across more people, so it does not improve their economics. In other words, unlike common fund orders, equalization orders will not make an open class more viable ex ante and won't encourage organizers to file them open initially. So that's not a good workaround. The second is closed classes. Now, we've already mentioned the shortcomings of returning to that type of system. Commission rates are going to go up, participation burdens are going to go down, fewer investors will join, fewer cases will be filed or settled, and so this workaround is also not ideal. The third is lawyers filing open classes with conditional fees, and to me, this is the potential game changer. Lawyers start financing cases, prosecuting them without funders on either a conditional or a contingent fee basis.
And what's the difference between conditional and contingency fees?
Well, in Australia, lawyers can already represent clients on a conditional fee basis, but are precluded from charging contingency fees. For both, payment depends on success. The difference is what the lawyers get for success. With conditional fees, they get their time, expenses, plus a potential uplift fee or bonus. With contingency fees, they get a percentage of the recovery, which is how it's done in the U.S. Conditional fee agreements are permitted by the Uniform Law, which is applied in New South Wales and Victoria by local application acts. A conditional fee may not be as lucrative as a contingency fee, but it is similar to the way that the lawyers are being compensated by the funders now. So from the lawyer's perspective, they're in a similar economic boat. Bringing cases on a conditional fee basis rather than with funders will require their full fee to be contingent. They're also going to have to front the money for the case expenses, but the larger firms with deeper pockets will have the ability to do that. So short term, this could lead to a consolidation of cases with a few of the larger firms and potentially marginalize the smaller players.
And what about longer term, Mike?
Longer term, external forces could reassert common funds or something similar, or may shift further contingency fee economics from those funders to the lawyers. Three things could happen. Number one, legislation could return the common fund order. The Brewster decision prohibited these orders under Section 33ZF of the Federal Court of Australia Act of 1976 and Section 183 of the Civil Procedure Act of 2005 for New South Wales. The legislatures could revise these acts, and there is some support for doing that. In January of 2019, the Australia Law Reform Commission recommended formalizing this court power to make common fund orders, and recently in the Bellamy's class action, the federal court judge there called for legislation to restore the order. So that's the first thing that could happen. Number two, judges hate losing case management tools, and they could find some other rule on which to hang similar orders. As I mentioned, some courts have held that the Brewster decision does not preclude judges' discretion to make common fund orders at the settlement stage. In the wake of that decision, the federal court amended its practice note for that relevant rule in a way that suggests to many that they embrace this view. Others say no. The same reasoning that precludes court discretion to make common fund orders at the beginning of the case applies equally later in the proceedings. In short, we have a split among the judges in the federal court. Others have suggested that the court's general equitable or interlocutory powers could also provide a basis for common fund orders. So that's the second thing. We may have the judges themselves revive the common fund order. And the third, and I think this is the big one, the law could change to permit lawyers to charge contingency fees. In Victoria, there's a bill now pending to permit them, and political momentum for it was stalled by COVID, which reduced the number of parliamentary sittings, but debate is set to resume on June 2nd. Despite opposition, many predict it will pass this year. But then again, that's been the story for some time. Contingency fees always seem to be on the horizon. Any of these longer-term changes could preserve our open class system.
So, Mike, if lawyers file open class actions with conditional or contingency fees, what happens to the funders?
Oh, this is very interesting. The relationship between law firms and funders differs depending on who's involved. Sometimes the relationship is synergistic, sometimes it's competitive. Some funders openly oppose legal contingency fees. Why? Because it would put the lawyers in the driver's seat for future case financing. Some funders support efforts to regulate funders, presumably because the regulation would reduce their competition from smaller funders unable to bear the compliance costs. In other words, how the funders and lawyers respond to things varies depending on their size, on the potential competitive impacts, and that's as between themselves and among each other. Short term, even with contingency fees, some cases will still require funders when the law firm lacks sufficient resources to self-finance. But I think longer term, funders will likely fund the litigation portfolios of the law firms directly rather than by contract with individual class members in specific cases. I think we're going to see larger funders like Omni, formerly IMF, potentially set up their own law firms. We've seen something similar with Maurice Blackburn and its affiliation with Claims Funding Europe. In short, the future is hard to predict. I think some funder regulation will happen. I think lawyer contingency fees may happen. And if both of those two things occur, it will significantly shift contingency economics from the funders to the lawyers, and there could well be a consolidation on both sides towards the larger players. But from the investor's perspective, as long as open classes still get filed, things should look the same. Rates might even go down if fewer participants need to get paid.